So after I die, the house is, say for talk's sake, it's left to my daughter.
Yes.
And she gets married, and she comes and she lives in the house, whatever, with her husband and her children, and they get divorced. Then
what happens at that stage?
Can her husband claim half the house?
Well, what I'll do is I'll actually illustrate that on the flip chart shortly and show you how that pans out in real life, if you like, and do a working example. You know, the main asset that you own is the family home, and I think we've already established that it's worth about £200,000. And clearly, you know, it's owned entirely in your name at the moment.
Okay.
So it's 100% sitting in your estate, if you like. So if you passed away today, you know, all of that house would be passed on to your children through the will that you have, isn't that right? And you've got 2 children.
Yes.
Child 1 and child 2. So as things sit at the moment, your will would state that upon my demise, all of my assets are to be distributed equally between my 2 children. And let's assume that's happened and the house is sold, and therefore the 200,000 is split equally between child number 1 gets 100,000, child number 2 gets 100,000. And they own that money, it sits in their estate.
Okay.
So we mentioned earlier on about the potential threats then that exist in that scenario. And we've got a number of them. There's divorce, for example. There are creditors. There's future long-term care costs of the children themselves. And then my personal favourite, marriage after death. What happens if one of the children dies, their partner gets remarried? You know, the assets that you've left your children could actually go out of the original family bloodline.
Okay.
And your grandchildren's inheritance could be affected. So these threats are very real. So by leaving assets absolutely from the will to the beneficiaries, it actually leaves this money open to all of these threats. So if child number 1's marriage ended in divorce, for example, maybe 50% of that money could go down the road to the ex-in-law.
Okay.
Is that what you would want?
Not at all.
If child number 2 ended up in financial difficulties, which is, say, easy enough done these days, and creditors came after them and potentially could take all of that money off them, there's 100% of that gone. Again, would that be something that you'd be happy with?
Not at all, no.
Probably not.
No.
So out of the 200,000 in this example that has been left to the children through the will, absolutely, 150,000 of it is up for grabs. So is there a way that we can stop that, you know, prevent these threats from dissipating or diluting the inheritance that they've left your children? And the good answer, or the answer is yes, we can. So in your scenario at the moment, because you're single, what we can do through the process, we can separate the house into 2 entities and convey half of the property into what we call a probate trust. It's a special trust. And that's done today. So the trust is actually created and half of the house conveyed into trust today. So effectively that half of your house now sits in the trust. During your lifetime, you're a trustee of the trust. Trustees are the people who are in control of the assets. You're also probably going to be the principal beneficiary, or PB. And then you'd have other beneficiary classes such as children, grandchildren, and what we call remoter issue. And what that means is that if, God forbid, all of these people, children, grandchildren, weren't there anymore and the estate was being distributed, the remoter issue covers anybody really in the bloodline that the assets can be distributed to. As I mentioned earlier, the lifespan of these trusts are 125 years. So today you convey half of your property into trust, provided we get through the time frames that I mentioned earlier for deliberate deprivation, the 6 months, the 18 months, and hopefully the 5 years.
Okay.
There's a very strong possibility this planning will stand. And what happens then if you went into long-term care, say in 6 years' time after doing the planning, so you now entered long-term care, the authorities come out to assess you for care, what assets you own and so on. Assuming there are no savings, they come out to value this half of the house. What do you think that half of the house is worth? And we've already established that in the government's own words, they actually said that half of the house is worth nothing.
Can't sell half a house.
Can't sell half a house. It has no value, not even on a commercial basis, because a potential investor buying that and taking a chance won't be able to charge any rent for 125 years, so there's no commercial value whatsoever. These are the government's own words, and these are contained in the CRAG regulations, the Charging for Residential Accommodation Guide, so they're there for everybody to see. just don't tell you about it. So what we've done then, by severing the tenancy, conveying half of the property into trust today, special probate trust, surviving the requisite number of years, or staying out of care for the requisite number of years, we've managed to make sure that the family home is protected against care costs. Moving on then to your eventual demise, and your will then says, well look, what I want now to happen is I want all of my assets left in trust and then distributed to the children. So during your lifetime, as part of the planning we'll have done here, we will also have set up what's called a family trust, and that will sit over here. Again, exactly the same. You're the trustee during your lifetime, principal beneficiary. The beneficiary classes are all the same. It's a 125-year lifespan. So upon your eventual demise, your will say you want the other half of your house left in the family trust for the benefit of children, grandchildren and so on. So now we have the entire asset effectively held in trust. Your will has stated that you want the assets sold and distributed equally amongst your children. So if the house is sold, 100,000 comes into this trust, 100,000 into this trust. But the difference now is, instead of before when there were no trust, the will leaving assets absolutely to the children, they're now settled into trust, and the trustees then actually loan the monies out to the beneficiaries through what are called loan notes. Now it's just a bit of paper, it's a legal document. The terms of the loan, because it's a private trust, the terms of the loan are probably going to be a non-repayment, non-interest bearing basis. So there's no repayment schedule or anything like that would be normally associated with a loan. But the children get their money. They can do whatever they like with that money. But crucially now, if somebody tries to take it off them, ex-partner, creditors, if they end up in care in the future themselves, that money is actually ring-fenced, because all they would do is produce the loan note which says, actually, this asset belongs to the trust. It's not mine absolutely. I don't own it absolutely. It's a trust asset. And therefore, ex-in-laws, creditors, etc. cannot touch that money that you've left your children. So by settling assets into trust, we've actually put a protective wrapper around those assets for the next 125 years. So the planning that you do today will last for 125 years and will benefit a number of generations.
Okay.
Any questions on that? Anything that you want me to expand on?
If one of the children took the 100,000 and went and bought a house with it,
yes,
which cost say 300,000, and again got divorced, this is all very depressing. Can that child then claim that that 100,000 back in some way?
It's a very good question. In actual fact, if you'd done this planning, then exactly what you've said would happen. If they used this money towards the purchase of a new house when they get married, for example, and that marriage ended up in divorce in the future, because this was originally a loan from the trust, although your daughter or son has put that into the new house, if that marriage ended in divorce, the loan note's produced, and the trustees say, actually, we're owed £100,000, so £100,000 of the sale proceeds of the marital home would have to come back into the trust here before any equity was split between your daughter and her soon-to-be ex.
So if the house cost 300,000, 100,000 goes back into the trust, and then the 200,000 left is divided between the couple.
Correct.
Right. Okay.
Correct.
And what would happen if the house wasn't sold? Say I left the house to one of my children, and he or she decided that they wanted to live in the house. I mean, do things just go on as normal? They can just move in, it's their home? Yes.
I mean, at the end of the day, it's a trust asset. It belongs to the trust. They're a beneficiary of the trust. So they have the use of the asset, they can live in it, they can do whatever they like. If that relationship broke down in the future, and X says, well, I want half of the value of that house we've been living in for the last 10 years, whatever it is, you can't get a penny of it, because it was never your daughter's in the first place.
Right.
It was always a trust asset. It didn't belong to her absolutely.
Brilliant. Okay, that's very clear. Thank you.